That is, we'll start off by defining the public sector, provide somewhat of a history of public sector, the labor relations that are related to public sector considerations, some public sector labor laws, and public sector unions. And this is, as you recall, about the same approach we took with respect to Chapter 2 in the private sector. And so the public sector really consists of a myriad of levels and jurisdictions of governmental units providing basic services. The three levels of the government are the federal, state, and local. The United States has a federal system of government with a national government and subnational entities officially called states, and our local governments would include cities, counties, towns, and villages, and such entities with local school boards and public utilities. So all three levels of the government have two roles as it relates to collective bargaining. In the private sector as creator and protector of collective bargaining, and in the public sector as the employer. The federal government through the National Labor Relations Board, state governments through similar state boards or labor departments, and many local governments through local labor management organizations or through appropriate courts at all levels are those to whom employees and employers will turn when there are labor issues to address. In 1968, the Memphis Sanitation strike ignited a burst of public sector union organizing efforts at all levels in government. Their success gave momentum to the public sector union movement. The membership of public employee unions skyrocketed to $2.9 million by 2.9 million people by 1975, 7 million by 1993, and 7.9 million by 2009. The Memphis strike was staged by 1,300 African-American sanitation workers who refused to work until they were paid minimum wage. As public sector employees, they were not covered by minimum wage laws. Over 64 days, the strike grew into a major civil rights struggle, and with workers demanding union recognition, wage increases, and an end to discrimination. The presence of national civil rights leaders and the participation of local clergy members and community members in boycotts and civil disobedience garnered national attention to the strike. As we said, in defining the public sector, we have a myriad of levels and jurisdictions. The three levels are federal, state, and local. And then within the local, we have also various different counties, towns, cities, villages. And so it can become a complex structure that we have to operate within, unlike the private sector where we generally have an employer and an employee. Each of these three roles of government have these two roles as it relates to collective bargaining. In the private sector as creator and protector of the collective bargaining units, right? So the federal government has created and protects collective bargaining rights through the National Labor Relations Act, through the National Labor Relations Board, as a result of the many different acts and laws that have been passed that we just talked about. And then these also have the role in a public sector as the employer. And so you can see they're wearing multiple different hats in their the federal or the levels of government. All of these levels of government are wearing multiple different hats. The federal government is divided into three main branches. That's the legislative, the judicial, and the executive. They have the same basic shape and perform the same basic roles defined for them when the Constitution was written in 1787. Congress, which is our legislative branch, passes the laws. The President is the chief elected executive officer and is charged with faithful execution of the law. The Supreme Court and all other federal courts have the judiciary authority vested in them by the Constitution to interpret the law. So we have a system of checks and balances which prevents power from being concentrated in any one of the three levels of the government. During the centuries since the Constitution first defined the federal system, the federal government has grown and evolved in response to economic and political events. Other areas that are thought to be in the domain of state or local government or the private sector have become national concerns and have resulted in federal interventions, such as Social Security, the environment, agriculture, and race discrimination. The day-to-day administration of the federal laws is in the hands of the various federal executive departments created by Congress to deal with specific areas of national and international affairs. And so, as we say, the president is the chief elected executive officer, and so that in his role, he acts in the executive branch, and he's charged with the faithful execution of the laws, versus the Supreme Court and all of the other federal courts, which have judicial authority vested in them by the Constitution, and they act to interpret the law. And so a state government is obviously one of the governing bodies of one of the 50 states. State governments and federal governments are legally dual sovereigns. The sovereign nature of government is one of the major issues discussed further. It explains why collective bargaining in the public sector differs from that in the private sector. State governments share power with the federal government, and under the Constitution, all governmental powers are not granted to the federal government are reserved for the states. And so we see that all states have a written constitution and a three-branch government modeled on the U.S. federal government. The executive branch of every state is headed by an elected governor. So the counterpart at the federal level would be the president, right, of the executive branch. And the legislative branch is typically a bicameral legislature made up of a Senate and a House of Representatives. And so that's similar to our, to the Congress at the federal level. The judicial branch is typically headed by a Supreme Court, which hears appeals from lower state courts. And so most states are subdivided into counties, which are considered subsets of the government, the state government, and share the state's sovereignty. So here we talk about again, we see the similarities, right, of the federal model, where we have an executive branch in every state within a governor. We have a legislative branch, which is a bicameral legislature made up of the House and of a Senate. And then we have a judicial branch headed by the Supreme Court, which hears appeals from lower state courts. And so a municipal corporation is the legal term for a local government. A municipal corporation is a political creation of a state that is composed of the citizens of a designated geographic area and which perform certain state functions on a local level. These political entities are called corporations because, unlike the federal or state government, they are not considered sovereign entities. Rather, they are created by the state as an entity capable of conducting business, but only as to such powers as are conferred upon it by the state. These fall into two categories. Those with general jurisdiction, and those would be examples such as cities or towns, and those with specific jurisdictions, and those would be entities such as school districts or public utilities. And so some states grant so-called home rule powers to municipalities in the state constitution or state statutes. Home rule is a flexible grant of power from the state to municipalities to determine their own goals without interference from the state legislature or state agencies. It allows municipalities to act on issues of local concern because they do not have to seek approval for their actions from the state legislature. Although home rule powers are broad, in no event may a municipality enact a law that is specifically precluded by state law or that is contrary to state law. The grant or prohibition of collective bargaining rights of local government employees is often the result of decisions made at the state and not the local level. The governmental authority most commonly exercised by municipalities is the exercise of what is called police powers. That's the power to enact laws governing health, safety, morals, and general public welfare. As we discussed, government employees are excluded from federal, state, and local National Labor Relations Act issues. Congress viewed the government not as an employer, but as a representative of the people, supplying certain necessary services. And so government-employed people were not considered to be employees, but public servants, and already existing systems protected them from arbitrary actions of private employers. That was not always the case, though. In the early 1800s, citizens were scandalized by the use of party patronage in federal, state, and local governments. These spoils systems caused the turnover of government employees on the basis of their political affiliation, not on their ability to or dedication. And this sets, over the time when our federal government or whenever government was being formed, it wasn't uncommon that the president, if you supported the president and you supported his views, regardless of qualification, you may have been appointed to a government position. When the president lost to the next president, then you lost your job. And this was coined, you've heard the phrase, to the victor go the spoils. And so this was reflective of that. That's reflective of what was in place there. However, in 1883, Congress passed the Pendleton Act, which provided for a bipartisan 3-member Civil Service Commission to draw up and administer competitive examinations to determine the fitness of employees to federal office. The act protected federal employees from being fired or failure to make political contributions, and actually forbade political contributions or political campaign contributions by certain employees. The Pendleton Act affected only about 10% of the federal employees at the time, but it enabled the president to broaden the merit system and was the foundation of the present federal civil service system. Rules governing hiring, firing, and discipline protect workers from arbitrary actions, and due process hearings give workers a forum to protest employment actions by government managers. The Pendleton Act also gave Congress the right to regulate wages, hours, and working conditions of public employees. To a large extent, the response to the Pendleton Act by both the executive and legislative bodies in the early 1900s demonstrates the hydra-headed nature of public sector labor relations. Two early federal employee organizations, the New York Letter Carriers of 1863 and the National Association of Letter Carriers of 1890, engaged in intense lobbying for improved salaries, better working conditions, and greater security for letter carriers and their families. In 1895, the Postmaster General prohibited postal employees from visiting Washington to influence legislation. President Theodore Roosevelt followed in 1902 with his infamous gag order prohibiting postal and federal employees, individually or through associations, to solicit members of Congress for wage increases or for other legislation. In reaction, Congress enacted the Lloyd-La Follette Act of 1912 with the intention of conferring job protection rights on federal employees and a restriction on the authority of the executive branch of government to discharge a federal employee for talking to Congress. The purpose of this act from the legislative perspective was to allow Congress to obtain uncensored essential information from federal employees or their associations. So you may recall from our earlier discussion that from the 1930s and 1940s, private sector unionization flourished under the protection of the National Labor Relations Act. These unions sought job security, higher wages, improved benefits, grievance procedures, arbitration rights, and recognition as a participant in the decision-making process. However, unionization grew later and more slowly for the public sector employees for a number of reasons. One reason was that unions held less attraction for many public employees because they already enjoyed some of the protections sought by private employees, that is, job protection through civil service systems, benefits like sick and annual leave days, 8-hour workday. In addition, the nature of government employment was predominantly white-collar, while unionized in 1940s and 30s was largely a blue-collar activity. And finally, there was the sovereign issue, which we'll discuss later in more detail. But it created a legal environment that was highly unfavorable to public employee collective bargaining. It kept employees at all levels of government from being able to approach government employers and engage in collective bargaining. And so again, here we just point out to the fact that the reason that the growth of unionization in the public sector was so much slower was that there was, the nature of government employment was predominantly white collar, while unionization in the 30s and 40s was by and large blue collar activity, and this, the highly legal environment that exists in the federal government employment arena. And so one act that we wanted to discuss is the Hatch Act, and that was passed in 1939, and it was amended by President Bill Clinton in 1993 to remove restrictions on federal workers' partisan political activity that had been in place for over 50 years. So the Hatch Act really limited the political activities of most federal workers, and because of this limitation of political activities, a great deal of flexibility with respect to supporting these federal workers was taken away from sitting politicians. The amendment actually removed a lot of the restrictions. The 1993 amendment removed a lot of the restrictions. And so, as we talked earlier, the key to employers' resistance to collective bargaining on the private sector was the desire to protect their private property rights. The National Labor Relations Act tried to balance these employers' private property rights against the employees' rights to organize and to bargain collectively. Although the purpose of the act was to place employees in an equal bargaining position, employers still held all rights not taken from them at the bargaining table. If we contrast that with the public sector governments, they are backed by judicial decisions. They were able to resist collective bargainings for many years by relying on the sovereignty doctrine. That's defined as the supreme, absolute, and uncontrollable power by which an independent state is governed. In a democracy, the source of that supreme power is the people who have vested their government with rights and responsibilities as caretakers of that power. The sovereignty doctrine requires that the government exercise its power unfettered by any force other than the people. That's all of the people. So since collective bargaining was seen as a threat to that sovereignty doctrine, for if any government was to share decision-making authority with employees, it would affect the way the government provides services and the amount of the services that those would cost the taxpayers. However, the sovereignty doctrine had numerous weak points. First, government contracted extensively with private sector contractors, and the negotiation of those contracts took place bilaterally. Second, the sovereignty doctrine can no longer be used to support the theory that government, the ruler, can do no wrong when the Supreme Court has allowed citizens to claim civil rights violations against state and local governments and torts and contract violations against local governments and other municipal corporations, subjecting them to monetary damage and remedial actions. So let's talk about a few significant key public sector labor laws. One was an executive order, which was signed by John F. Kennedy in 1962, allowing federal employees bargaining representation, forms of employee recognition, and the right to collective bargaining. What is important about Kennedy's original order of 1962 is the lightning effect it had on organizing drives among federal, state, and municipal employees. The order served as a signal to organized public workers as much as the Wagner Act of 1935 had stimulated the growth of industrial union membership in the CFO and AFL. The effect of this executive order was to send public sector union membership rolls soaring. Before 1962, only 26 union or association units in the executive branch of the federal government had union shops, and they represented only about 19,000 workers. However, 6 years after this executive order, there were 2,305 bargaining units with a total membership of 1.4 million employees. A number of unions represented federal workers. The largest was the American Federation of Government Employees. Over the 10-year period between 1962 and 1972, the AFGE, American Federation of Government Employees, grew from 84,000 members to 621,000 members. The postal workers and letter carriers unions also experienced growth in that period. There was a deficiency, though, in this act, and it was the lack of any central authority to determine bargaining unit recognition and resolve disputes. Many decisions were left to agency heads who were the immediate supervisor of the labor organization's members. The most significant difference between the National Labor Relations Act and this executive order was the right to engage in work stoppages. Strikes were specifically denied to public labor organizations, and no substitute for a strike was provided, which left much of the power with the employers. In order to address this deficiency, Richard Nixon issued Executive Order 11491 in 1969, which established a Federal Labor Relations Council and an Assistant Secretary for Labor Management Relations. And the role of these organizations was to manage the labor relations systems and resolve disputes, such as which employees could be represented by unions, how elections for selecting union representatives run, and whether any of the provisions of the executive orders were violated. We also have another initiative of the Nixon administration, and that was the passage of the Postal Reorganization Act of 1970, which made the U.S. Post Office, or United States Postal Service, USPS, an independent agency of the executive branch. The USPS was permitted to operate using business principles and charged with generating enough revenue to support the cost of the service it provides by allocating those costs among the many users of the postal system. This did not come without a struggle, though. The unions regarded the reform as privatization. That is, taking an otherwise public or government service and making it private. And the letters carrier union local in New York started a strike that soon would involve 1/3 of postal workers, which was the first major strike by federal workers in the U.S. history. We also want to talk about the Civil Service Reform Act of 1978. This is also known as the Federal Labor Relations Act and Reorganization Plan No. 2, which governed federal employee labor relations. The act is modeled after the National Labor Relations Act, and it gives federal employees the right to join or not join unions and to engage in collective bargaining. It places central authority in a 3-member panel, the Federal Labor Relations Authority, who are appointed by the President of the United States. The FLRA, or Federal Labor Relations Authority, oversees creation of bargaining units, conducts elections, decides representation cases, determines unfair labor practices, and seeks enforcement of its decisions in the federal court. We also see the National Security Personnel System, and they oversaw about 760,000 federal government civilian employees, and these employees are housed or belong to the Department of Homeland Security and the Department of Defense. This, however, was not successful because the unions successfully objected in court to the actions, to the changes in the labor relations section in the National Security Personnel System. And as a result of that, the National Defense Authorization Act for fiscal year 2010 repealed the statutory authority for the NSPS and directed the Secretary of Defense to provide for the conversion of all NSPS employees and positions back to their original status by January 1, 2012. And so this table, 3.2 on page 92 of the text, really provides a chronology of the major events in the federal public sector labor relations area. And so you can see we talked about the Pendleton Act in 1883. The American Federation of Government Employees, one of the first sectors, was formed to lobby for legislation. The Hatch Act, the executive order by John F. Kennedy, the Civil Service Reform Act, and then the Hatch Act. And so I would kind of read through all this and be somewhat familiar, not necessarily about the particular year, but at least the some of the characteristics of some of the government actions noted here. And so it's important to note that there really is no federal law currently governing the collective bargaining relationship between states and local governments and their employees. Congress recently considered a bill, the Public Safety Employer-Employee Cooperation Act, which would have given local government public safety officers the right to join a union, to have the union recognized by their employer, to bargain collectively over terms like hours, wages, and terms of employment. And it would have allowed the parties to seek mediation to resolve differences, but it would not permit the workers to strike or enforce force their employers into binding arbitration. However, the bill died in Senate in July of 2010. And so rather than having some comprehensive nationwide approach to collective bargaining, what exists is a myriad of state statutes and local ordinances that address collective bargaining rights on the state and local level. 42 states have enacted legislation granting public sector collective bargaining rights. The state laws generally fall into 3 categories: comprehensive public sector collective bargaining rights, targeted public sector collective bargaining rights, or restrictions to public sector collective bargaining rights. And so targeted collective bargaining laws either grant rights to most states and local local employees, but exclude some by name, or grant such rights exclusively to one or more classes of public employees, such as firefighters, policemen, or teachers. These targeted collective bargaining statutes often refer to the labor relations process as meet and confer rather than collective bargaining. Restrictive collective bargaining rights either prohibit public sector collective bargaining or are silent on the subject, which means the government employees have no right to negotiate with their employers. In the absence of state law, state governors may issue an executive order similar to the one issued by President Kennedy that gave federal employees collective bargaining rights, or an attorney general might issue an official attorney general's opinion granting such rights. And so then we know that local, county, and municipal governments may also adopt collective bargaining laws or by practice recognize and bargain with employee organizations. Although state and local laws differ as to particulars, some patterns do emerge. Legislation is more favorable to collective bargaining in the northern, northeast, midwestern, and far western parts of the U.S., and the Sun Belt states located along the lower Atlantic coast, the southeast, the southwest, and the southwestern Rocky Mountain states generally do not have comprehensive public sector laws. And so this figure shows us that which these 42 states that have enacted legislation granting public sector collective bargaining rights. And those 42 states are listed with the diamond shape pattern. And then we have another set of notations where we have identified states that have targeted, which means that there are some local government or such as police, firefighters, and teachers have collective bargaining rights. We have other states that have restrictions. There are no laws or deny rights. And then we have those that are governed by executive order or court opinion. And it's figure 3.2 on page 93 of the text. And so where we do have public sector unions today, they roughly fall into three categories: associations or fraternities, public sector only unions, and mixed unions. Many sector unions have their roots in professional associations and fraternities that developed before widespread public sector collective bargaining. The National Education Association is the largest professional organization in the world, with over 3.2 million members and affiliates in every state, as well as in over 14,000 communities. The NEA state affiliates regularly lobby state legislators. They seek to influence education policy and professional standards for educators and act to protect academic freedom and the rights of school employees. At the local level, affiliates perform a variety of activities which range from fundraising for scholarship programs to bargaining contracts for school district employees. The American Federation of State, County, and Municipal Engineers is an example of the public sector only union that organizes multiple sectors of public employees. This American Federation of State, County, and Municipal Employees is the second largest public union in the United States and is the fifth largest national union in the AFL-CIO with over 1.4 million members. It represents public employees and healthcare workers throughout the United States, Panama, and Puerto Rico. And then finally we have this idea of a mixed union. And so that's something like the International Brotherhood of Teamsters. Teamsters, which originally was organized by drivers of horse teams, currently represents such public service employees as deputy sheriffs, corrections officers, those who provide security in public buildings, nurses, blood collection personnel, and aides who care for the elderly and veterans, school janitors and bus drivers, and workers who maintain roads and public utility systems. So if we just look at some of the differences between public and private sector labor relations, we see that collective bargaining on the private side is largely shaped by market forces, right? The private organization is driven by a profit motive. Its assets and income must exceed liabilities and expenses, or it's not going to be around long. So private sector employers and employees must be responsive to customers because it operates in a competitive arena, and if it doesn't provide its customers with best value, customers will go elsewhere. This contrasts with collective bargaining in the public sector, which is ultimately shaped by political forces. The services provided by the government are generally not available from other organizations, and they are critical generally to areas like health, safety, and welfare that include education, public safety, public health, social services, and public utilities. So it's important to recognize that government, unlike private sector employers, have no competition and generally has a monopoly position on the market it serves. Really, and as we say here, that the core difference here is that government is not a business. And so that concludes Chapter 3 of what we're going to talk about. Now, the chapter goes on in the reading to talk about the collective bargaining's impact on government, also the bargaining differences in the public sector, such as multilateral bargaining and open negotiations. And so I would encourage you to go ahead and please read those. because it also talks about the idea of union security, and that's referring to the ability of the union to grow and perform its collective bargaining role without interference from the management or other unions. It talks about this idea of free riders and cheap riders, which free riders are employees who are in a unit represented by the union, but are not covered by the collective bargaining. That are covered by the collective bargaining, but cannot be required to join the union or pay any union dues or fees. And cheap riders are those who are covered by the collective bargaining agreement but cannot be required to become union members, but they are required to pay something or a fair share to the union for the bargaining and representation services they receive. And we also talk along the lines of the size of the public sector bargaining units and the right to strike. And so for employees in the private sector, the right to strike is guaranteed by the National Labor Relations Act, but public employees are generally prohibited from striking, making the right to strike a major issue for public sector employees. We also go on to talk about alternative dispute resolutions, and with respect to public sector employees, we have legislation that allows public sector collective bargaining but prohibits strike, which often details the procedures available to resolve an impasse. So we have mediation, which are provisions provided in most states with collective bargaining in the public sector. As with the private sector, the mediator has no independent authority but uses acquired skills to bring the parties back together. We have fact-finding and advisory arbitration, which can be far more successful in the public sector than in private sector because of political issues. So with fact-finding and advisory arbitration, an unbiased third party examines the collective bargaining impasse and issues findings and recommendations. Because the findings are generally made public, one side or the other runs the risk of losing public support for their position if the finders of fact make a reasonable recommendation. Then we have interest arbitration, which allows usually an arbitration panel to make a final and binding decision on a negotiation dispute. It's been used in the public sector to resolve impasse as an alternative to economic pressures of a strike used in the private sector. We also talk some about the current public sector challenges, such as privatization, which essentially relates to outsourcing in the private sector, and it refers to a process in which governmental employees are replaced with private sector workers through a contract with an outside employer for the purpose of reducing overall cost. And so we cover a lot in this chapter. Again, I would encourage you to go back and make sure you've read it. Don't let this substitute as a read for the chapter, and think about what you're reading in the context of public sector, and in your mind, try to relate it back to what we talked about in chapter 2 with respect to private, the private sector, and where these differences exist, and whether there are, are there similar alternatives in place for the public sector, even though they may have a slightly different twist to them. And don't hesitate to contact your course facilitator with any questions or concerns about this, and thanks for your time.